This case was presided over by District Judge Richard Scotti, who was overseeing jury selection in a molestation case in Las Vegas.
You can't be fair and impartial to both sides. You're going to completely throw out our entire justice system because you don't want to be fair and impartial.
The accused, Jose Azucena, is on trial for a grievous crime and faces life imprisonment if convicted. Azucena is charged with 40 counts, including child sexual assault, lewdness, and kidnapping. Prosecutors contend that he abused his role as a family friend to attract and mistreat 5 young girls at his Las Vegas apartment complex from 2014 to 2016.
The victim says he took her into his apartment where he tied her up and taped her mouth shut before assaulting her.
Prepare for a jaw-dropping twist. Before the trial can proceed, Judge Scotti must ensure that all jury members pledge to remain fair and unbiased.
Okay, so can you be fair to both sides?
However, a female jury member expressed concerns about her ability to remain unbiased if selected for the jury.
I think I would be biased.
Upon hearing this, Judge Scotti lost his composure.
You didn't say that yesterday.
Well, I said I had
No,
other
listen,
issues.
what we're not going to have in this jury is people coming in overnight and thinking of and try to make up now so they can get out of the jury. That's not going to happen, all right? Now, what's going on here? Tell me what's going on.
I said I had other issues yesterday, and you said you'd get back to me.
All right, so why you got issues? Why can't you're saying that you can't be fair and impartial to both sides? You're going to completely throw out our entire justice system because you don't want to be fair and impartial.
Your Honor, may we approach? Your Honor.
No, you can't approach.
And subsequently, he dismissed her from the jury.
Off this jury. You're off this jury. You're removed. Go home. All right?
Jose Azucena was initially sentenced to life imprisonment. However, Judge Scotti's conduct during the trial raised serious concerns, leading to the overturning of Azucena's conviction. A Nevada Supreme Court panel found that Judge Scotti's behavior had created an intimidating atmosphere that compromised the integrity of the jury panel. This situation cast doubt on whether his actions influenced the guilty verdicts. Despite this, no other jurors reported bias or concerns about their impartiality. Nevertheless, the court deemed the atmosphere created by Judge Scotti's behavior as unacceptable. They decided that a different judge should oversee Jose Azucena's new trial.
You're going to completely throw out our entire justice system because you don't want to be fair and impartial. Yeah, you're off this jury. You're off this jury.
This is the infamous case of Monica Contreras. In August 2011, Monica Contreras, a 28-year-old woman from Los Angeles, went to a courthouse with her 2-year-old daughter for a divorce hearing. During this time, she experienced a distressing incident that initiated a series of events involving accusations, cover-ups, and legal battles. While in a witness room, Court Marshal Ron Fox, assigned to the courthouse, was supposed to search her for drugs. Instead, he allegedly assaulted her, groping her, and instructing her to lift her shirt. Feeling violated, Contreras approached another marshal, James Kenyon, to report the incident. However, Kenyon and Marshal Doniger not only disregarded Contreras' complaint, but also turned their backs on the situation. However, the situation took an even more bizarre turn. As tensions escalated, Fox, the court marshal accused of the assault, ordered Contreras' arrest in response to her allegations.
Jimmy, I got court. I still have to do this, so arrest her.
Alarmed, Contreras questioned the reason for her arrest. Fox was quick to respond, already having an explanation prepared.
Hey, cutie.
Because you're making
I'm not making false allegations on, sir. Why would you put me in this position? I'm a good person.
Still reeling from the shock, Contreras faced an ultimatum from the cunning Fox. He told her that to avoid arrest, she would have to retract her accusations against him.
I don't want to deal with this, please. I just want to end it. Okay, it was all lies. It was all lies. It was all lies. It was all lies. Let me go home, please. Let me go. It was all lies.
Defiantly, Contreras approached the microphone and courageously addressed the court. She asserted that Fox had taken her into a room and instructed her to lift her shirt without any witnesses present.
Put me in the room. actually lifted my shirt without a witness.
Following her statement, Contreras was taken into custody, resulting in her daughter being placed in the care of Child Haven.
You actually lifted my shirt without a witness.
Contreras' claims were later validated by an internal investigation conducted by the Clark County courts. As a result, she received a $200,000 settlement from the court. Marshal Ron Fox was fired, and another marshal, James Kenyon, was relieved of his duties. Hearing Master Patricia Doniger also left her position. Despite these actions, Ron Fox denied the accusations and initiated legal proceedings, filing a lawsuit against his dismissal, claiming it was unjust. This case revolved around Sigfredo Garcia. In 2014, in Florida, Garcia was involved in the killing of law professor Dan Markle. Shortly after, the police connected him to this heinous act and decided to charge him. During the trial, Garcia's defense attorney seized the opportunity to argue his innocence before the judge.
Counsel for the government, counsel for the co-defendant, ladies and gentlemen of the jury. 7 years. 7 years in Florida State Prison. That's what Luis Rivera got in exchange for his participation in a first-degree case. And who gave him a 7-year deal offer? The prosecution. So you have to think and you have to ask yourself, what did the prosecution get in return for the deal of the century? What did the prosecution get for giving a defendant with an extremely long criminal history, including a recent federal conviction for racketeering as a Latin king? What did he give? Did he give the information of a mob boss or a kingpin, a foreign or domestic terrorist, a hiding school? No. He gave up Sigfredo Garcia. And why does that matter? Why does what he gave up matter? Why does Luis Rivera's information in this case matter? Because as it's clear from the government's opening statement, their focus in this case is on the Adelsons. Donna Adelson, Charlie Adelson, Wendy Adelson. That's who their real targets are. And so what do? They go after the low-hanging fruit. They go to Luis Rivera, who was charged with first-degree and subject to the penalty. And they tell him, we're going to cut you a deal where you only have to serve 7 more years. 7. So what does he do? He sits with his lawyer, Chuck Collins. You're going to see a tape. You're going to see an interview that the government's going to play where law enforcement officers are sitting at a table with Luis Rivera and his attorney, Chuck Collins. And it's going to be considered his initial statement, okay? And they're going to ask him things back and forth, and you'll see that Luis Rivera gives a statement that in essence becomes the prosecution's parrot. He says pretty much everything that coincides with their strategy, with their theory of the case. What they don't tell you and what they don't show you is that before the video camera turns on, law enforcement is in one room, Luis Rivera and Chuck Collins are in another. And the detectives go not to Luis Rivera, but to Chuck Collins to exchange questions, to prepare Luis Rivera for when the lights turn on, to make sure that your story fits, that your story is in unison with what the government wants you to say. They don't show you that. But you're going to hear about it because the testimony is what it is. And the testimony is that the government spoon-fed Luis Rivera as to what his testimony has to be. Now, why does that matter? Well, let's talk about some of the things that the government said in their opening and what they believe that the evidence is going to show. They talked about an initial trip where Luis Rivera says that him and Sigfredo Garcia traveled from Miami to Tallahassee to scope out the scene or to commit whatever their argument was. And the reason why Luis Rivera has to say this is because there's cell And if you don't think that's good enough, there's more. During that first trip up, Luis Rivera, who was driving, who rented his car, he gets pulled over by a Florida Highway Patrol officer, Trooper Downing. And Trooper Downing testified, and you'll hear that his testimony is that when he issued the citation, that Luis Rivera was alone in the car. And he knows that because he indicated it on the citation. The government has hitched their wagon to Luis Rivera. That's this case, okay? There's going to be speculation and an additional theory of why the Adelsons wanted to hurt Dan Markel. That's an additional case. This case, Sigfredo's case, is premised around Luis Rivera. And I'll tell you why. Because the only person that can put Sigfredo Garcia at the scene, the only person who can tell you that Sigfredo Garcia got out of the car and purportedly Dan Markel is who? It's the guy who got the 7 years. The guy who got the deal of a lifetime. It's him. That's their case. You will hear statement after statement after statement from Luis Rivera, who adds and subtracts and changes and alters his testimony from A to Z. I mean, it's crazy how much he changes his story. He tells the government, which they're going to tell you, we got 100 grand for this. And for driving up to Tallahassee, you know what I got as the driver? I got 35 grand. So wait a minute, let me get this straight. Supposedly, Sigfredo Garcia was hired and given $100,000. That Katie Magbanua was solicited by Charlie Adelson. Okay. Now, the evidence is going to show that my client has children with Miss Magbanua. He loves her. That's his girlfriend. That's his wifey.
Once the jury was informed of the suspect's actions, they recommended a course of action for the suspect's future to the judge, who then quickly determined the appropriate sentence. This case followed a similar procedure.
Russ Meisel, is the jury arrived at a verdict?
Yes, sir.
We have handed the bailiff, please. State of Florida versus Sigfredo Garcia, we, the jury, find as follows: as to aggravating factor, the capital felony was committed for pecuniary gain. The jury has found the state proved beyond a reasonable doubt that this aggravating factor exists. We, the jury, find as follows: as the aggravating factor of the capital felony was a homicide and was committed in a cold, calculated, premeditated manner without pretense of moral or legal justification. Jury has found the state proved beyond a reasonable doubt that this aggravating factor exists. As to step two, we, the jury, find as follows: as sufficiency of the aggravators, the state proved beyond a reasonable doubt that the aggravating factors are sufficient to warrant a sentence. As to step three, we, the jury, find as follows: as the weight of aggravating factors and mitigating circumstances, the state did not prove beyond a reasonable doubt that the aggravating factors outweigh the mitigating circumstances. It's dated and signed by the foreperson. Having made that conclusion, there was no reason to go to step four. Either side wish to have the jury polled?
No, sir.
No, Judge.
This will conclude your service with us. We do appreciate the time and the attention that you have given us. I know it's been a long and arduous experience for you. We very much appreciate the time and the attention that you've given us. You've been very cooperative, and we appreciate that. You've been a very reliable jury. I try to run things on time, and y'all have by and large cooperated very much with that, and I appreciate that. Once you start letting things get out of whack on that, you end up sitting in the jury room a long time, and I try to avoid that. Let me discuss a couple of things with you. It is quite possible that you will be contacted by someone to discuss your deliberations. You're free now to talk about it if you wish, but I want you to understand you also have an absolute right not to discuss your deliberations. You have every right to simply say you'd prefer not to talk about it. Again, that's up to you. I don't know what kind of person you might be contacted by, but you might be contacted by someone wishing to find fault with what you've done. As I've said, you have every right to simply say you prefer not to talk about it. You will be receiving a letter from the court with our thanks. It will include in that an opportunity to seek counseling that we have arranged. That's something for you to decide. It won't be long term, but they will at least you get started with some free counseling that the court has arranged. Then from there you can decide how you wish to proceed. Sometimes we don't think about the impact we have on jurors. I do try to consider that, and that's something that we have arranged. You're done now, so I did want to comment on one thing that you were not advised of, just in case it's something that you were curious about. I know you've been kind of cloistered from hearing about the case. In Ms. Agbanowa's situation, to let you know that the state was not seeking the death penalty as to her. I don't know whether that was something that maybe you were curious about, but pondered that maybe some of y'all might be wondering what that situation was. It was decided before trial that you were not to be told that, for various reasons. But I thought that might be something you would be interested in knowing. That matter will be reset, and we have not picked a new trial date on that, but eventually we will have a new trial date, and that matter will proceed. So probably longer than y'all wanted to hear. I know y'all ready to get out of here. We do appreciate all the time and attention that you've given us. We'll let you step out. The court administration people will get you out of the building. Have a good day. Thank you. I'm going to need about 25 minutes. We're going to proceed on this sentencing. I haven't finished my reading, so I'll reconvene at 11 o'clock and give me a chance to finish the reading on what's been provided to me. So we'll reconvene for sentencing at 11 o'clock. Right?
Yes, sir.
Sigfredo Garcia's fate was ultimately decided by the judge after all the evidence was presented and considered.
Is there any reason not to proceed with sentencing at this time?
No, Judge.
No, sir.
Any technical objections to the score sheet?
No, Judge.
Defense wish to be heard.
No, Judge.
Does Mr. Garcia want to say anything?
No.
All right. State.
Judge, the state, obviously you can only do one sentence, but the state would request a 30-year consecutive sentence on the conspiracy charge. And we do not have any evidence to present other than the statements that Your Honor has already reviewed.
Sorry, I left my notepad on my desk. He's getting that for me. I have reviewed the victim impact letters. thoughtful and touching comments. Sanganin, come forward with your client, please. As the jury having found you guilty of first degree and conspiracy to commit first degree we'll take that up because you need to perfect the record before you move to withdraw, but we'll review that at that point in time.
Yes, sir.
Does that leave anything outstanding from anyone?
No, sir.
Anything further?
No, Judge.
All right. Good luck to you, sir. We'll be in recess.
John, may I vote?
Sure.
This incident centered around a man named Tremaine Wilburn. On August 1st, 2015, in Memphis, Tennessee, Wilburn tragically took the life of a police officer. Later, the police decided to charge him for the crimes. During the court proceedings, the prosecution revealed details of the suspect's disturbing actions. Here, the prosecutor made her statements regarding Wilburn's crimes.
You may proceed.
On August 1st of 2015, Sean Rose in his police department position. He was assigned to Mount Horizon. And his call number you called from over the radio, was 364 Delta. 364 being the number, Delta being the hours that he worked. Saturday, August 1st at 9:04 p.m., Officer Sean Bolton left an alarm call. Shortly before 9:18 p.m., Officer Bolton attempted to call for help for the last time. That was 364, if you can understand.
First report on 40 Channel Raven.
you don't mind, I'll stand by while I try to continue raising them out in the message city fire. 364 Delta Cars Officer Bolton, 364 Delta Cars Officer Bolton. Last thing he was showing on was an alarm, 2871, Business Park Drive, but he cleared that at 904. Now I hear fine. Well, I have his location. 364 Delta. Y'all got a man down. Where? Okay. You see me too? Oh, it's all right, man. Hurry up, you believe why it's bad, man. Please hurry up. Officer inside. I'll check with them for ETA.
After exhausting all available methods, the prosecution finally exposed the suspect's true nature in court.
He saw a regular statements, parked backwards on the street, and it looked like something was happening inside. Turned the spotlight on it. When he did, the driver of the vehicle jumped out of the car and took off running the street. Officer Bolton got out of his car and walked up to the passenger side of that representative. He looked in the window and he could see the car, he could see scales, and he could tell that it was actually some sort. What he didn't know that night was that the passenger in that vehicle, that Tremaine Wilborn, had a prior felony conviction for a crime of violence. And despite having been told by a court that he could no longer possess a firearm, he had a 9mm in his waistband and he was not going to prison. Officer Bolton got Tremaine Wilborn out of the car. And as soon as he got him out, the store was. Marquise Wright was standing outside his house smoking a cigarette when all this transpired. Marquise saw the defendant shove Officer Bolton, step back, Officer Bolton stumbled backwards. Daughter playing in front of their house, and the bullets had shattered the glass on the front of the house, and the granddaughter had to crawl into the background. Miss Crutchfield came out of her house walked to the end of her drive and looked down and saw Sean Bolton. Christopher Lear also came out before his nephew. We initially didn't see Sean Bolton, but he walked around to the backside of his squad car over by this Crutchfield's drive, and we saw him there lying face down as well. The officer's down still, and this officer never his hand was still, his belt never pulled down. He was lying face down on the driveway, holding his face. They called 911. This Crutchfield called 911. Other neighbors came out. They tried to call 911. Mr. Lanier got down on his hands and knees, crawled over to Officer Bolton's microphone, his walkie-talkie, and pushed the button. That's what you heard there. He was trying to key it up and trying to call for help for Officer Bolton. Officers arrived on the scene, tried to do CPR, tried to revive him, tried to put a breathing mechanism on his face, but it was hard because his face was gone. So they were holding it together with rubber gloves to try to get the breathing apparatus on his face. At that point, they weren't aware of all the other 10 other, 8 of which had struck. As they were there trying to get the ambulance in, trying to keep Sean alive, a call came in. Mr. Diver, who lived 2 streets over. He told the 911 operator, somebody just came up, put a gun to my head, said, I just the police. Give me your car, I'm taking it. Mr. Diver gave him the car. Mr. Diver's car was found a couple blocks away. During the course of the investigation, Mr. Marquis Wright identified the name of the person. The driver of that red Mercedes that had gone and ran identified the name of the person that was in the passenger seat of his car. Fingerprint evidence on the scene identified the defendant, Tremaine Wilborn, as the person. DNA evidence, which you'll hear from the DNA expert on it also. DNA evidence showed that it was in fact.
In the courtroom, the defense attorney presented information asserting the suspect's innocence, reflecting similar actions in this case.
On one hand, you've got Sean Bolton, who's an officer with the police department. On the other hand, you've got Tremaine Wilborn, who's a young man, troubled background, who's fighting for his life. This is not going to be a case that involves a question of who, what, where, it's a question of why. As we talked about during jury selection, why a crime happened, why an offense occurred is important. Because things like this don't happen in a vacuum. You've got to evaluate the totality of the circumstances. You've got to go back in time and look and see what actually happened. And although there is a penalty case, there's not much doubt as far as what happened. Many of the facts in this case are undisputed. There's no question that Tremaine had a and he shouldn't have. We've accepted responsibility that he's been convicted of being violent felony offense before August 1st of 2015. And he absolutely should not have given your Next, there's no dispute that Tremaine was with David Lanier. We expect that you'll hear testimony that Lanier and Tremaine have been friends for several years, and that Lanier had come to take Tremaine away when Tremaine had been having issues with people in his neighborhood. And so Tremaine got into a car with Lanier and came to an address on Summerlin Avenue. As Mr. Bolton approached, David Lanier ran away. David Lanier fled. Tremaine, however, stayed on. Little did Tremaine know that there would be an altercation. Little did he know that he would get pulled from the car. And little did he know that there would be a with respect to we expect that you'll hear testimony from Tremaine and we expect that you'll hear testimony that Tremaine shot several times, that he was in fear of his life. We expect that you'll hear testimony that a few weeks earlier, a young man named Gary Stewart had been killed by Judge.
We'll sustain that objection, Mr. Gangley. We discussed that previously. Ladies and gentlemen, in order that you disregard anything about anybody else, then we'll disregard that. That's not relevant to this case. Mr. Gangley, may proceed. Yes, sir.
We expect that you'll hear testimony that Tremaine ran away. With respect to the aftermath of the shooting, there is no doubt that Tremaine or Jack invested that. We accept the responsibility for that. And Tremaine hurt himself. The bottom line is that Tremaine was panicked. Tremaine didn't know what was going to happen. And Tremaine was not killed. This is what happened. This is a sad case. It's a tragedy.
The judge's responsibility is to decide the case after hearing all statements from both parties. This case followed the same procedure.
The jury has reported to the deputy they have reached a unanimous verdict on this case. Is everyone ready to receive the verdict of this jury?
Yes, sir.
Those family members that are here from Mr. Will, but this verdict is, you and I will find out about it in just a few minutes. But I'm going to require everyone to respect the verdict of the jury. You cannot have any emotion, cannot show any emotions, whether it's good or bad and different. You must respect the verdict of the jury, cannot show any emotions at all. If there's anyone who feel they cannot follow that court's instruction, please leave the courtroom at this. That you have indicated that you reached a unanimous verdict on this case. Do all of your members indicate that you have in fact reached a unanimous verdict? Yes. Like the record reflected, all the members, I have all the members of the jury have responded in affirmative. Ms. Miller Smith, if you can have that jacket, trial jacket, Deputy Smith, for me, please, ma'am. Thank you, Deputy Smith.
Welcome to Judge Conference.
And this verdict reads as follows: State of Tennessee versus Tremaine Wilborn, docket number 1600515, count 1. Read: the jury found the defendant guilty of first degree charged in count 1 of the indictment. Count 2, we, the jury, find the defendant guilty of carjacking as charged in count 2 of the indictment. Count 3, we, the jury, find the defendant guilty of possession of a firearm during the commission of or attempt to commit carjacking as included in count 3 of the indictment. Count 4, we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 4 of the indictment. Ms. Miller, Ms. Miller Smith, is this your verdict now?
Yes, sir.
Mr. Meadows, is this your verdict, sir? Ms. Strong, is this your verdict now? Mr. White, is this your verdict, sir?
Yes, Your Honor.
Ms. Shaw, is this your verdict now?
Yes, sir.
Mr. Thomas, is this your verdict, sir?
Yes, Your Honor.
Ms. Freeman, is this your verdict now?
Yes, sir.
Mr. Hill, is this your verdict, sir?
Yes, sir.
Mr. Clay, is this your verdict, sir?
Yes, sir.
Ms. Christian, is this your verdict now?
Yes, Your Honor.
Mr. Williams, is this your verdict, sir?
Yes, sir.
And Ms. Thomas, is this your verdict, sir?
Yes, sir.
Ms. Thompson, I apologize to you, sir. Is this your verdict, sir?
Yes, sir.
Thank you, ladies and gentlemen of the jury. Ladies and gentlemen of the jury, I'm told by Deputy Smith that your lunch is here. We're going to take a lunch recess for about an hour and 30 minutes. It is 12:14. We'll resume at 1:45. What I told you on Monday and Tuesday and all week, if you found Mr. Wilborn guilty of first of a separate sentencing hearing, you make a determination as to what the sentence should be on count 1, the first case, and that is either life in prison without possibility of parole or penalty. So we'll resume in 1 hour and 30 minutes to give the lawyers a chance to marshal together any proof that they need to have presented at that sentencing hearing, and we'll proceed with sentencing at 1:45. You still cannot discuss the case amongst yourselves with anyone else, and that should give you enough time also to step outside of the building and get some fresh air, and your lunch should be here. You follow Deputy Smith. I see an hour and 30 minutes. Thank you all. Charged in count 1 of this indictment, and the jury having found you guilty of carjacking as charged in count 2 of the indictment. The jury having found you guilty of possessing a firearm in the commission of a dangerous felony offense to which carjacking as included in count 3 of the indictment. The jury having found you guilty of being a convicted felon in possession of a firearm as charged in count 4 of the indictment. Ms. Wilborn, in this judgment of this court, if you are guilty, this court, as 13 jury, does affirm the verdict that the jury has reached in this case, and the court finds that there is more than enough evidence that any rational, reasonable trier of fact could have, in fact, should have found you guilty of the offenses as indicted in counts 1 and 2 and 4, and that's included in count 3. And this court does affirm the verdict that the jury has reached in this case. If there's a bond that has been set in this case pursuant to Tennessee Statute 40-35-115, we want to order that any bonds that have been previously set in this case will be revoked, and Mr. Wilborn rather will be detained without a bond pending further proceedings on this case. State, do you anticipate presenting additional proof at sentencing?
Yes, Your Honor.
How many witnesses do you anticipate, Mr. Lawyer?
4.
Mr. Gangle, Mr. Wilborn anticipate presenting additional proof at sentencing?
We do, Your Honor.
And all the witnesses, how many witnesses, Mr. Gangle? I'm sorry.
It would be at least 4. Your Honor, if they're unavailable this afternoon, then we have until Monday morning to get them here.
Ms. Gangle, if they're unavailable, we'll certainly give you some money to make sure that Mr. Wilborn has all the mitigation proof that he needs to be presented. So if they're not available this afternoon, we'll certainly resume the sentences. Witnesses that he can here today. If not, we'll finish the sentencing hearing on Monday. And Mr. Gangle, I know you probably have, but if you have filed notice of mitigating factors, if you have a copy for the court's consideration, I'll start blending that into a sentencing charge also. Anything else we need to address before we take a lunch recess?
No, Your Honor.
court sat in recess until 1:45 p.m.
All rise. Call the court at recess 1:45 p.m.
Seeking to capitalize on the opportunity to persuade the judge of the suspect's innocence, the suspect's lawyer seized the chance to present evidence supporting his innocence.
Some of you will be affected by more. One choice of one may not reflect the choice of the other. And I want to emphasize this because it is, at this point, an individual choice and a moral decision that every single one of you has to make. Now, you've heard about Truman's life. You have heard from witnesses who came before you, and you have heard about the beginning of this tumultuous life. You have heard about the troubles of childhood and the exposure to violence, abuse, and other negative influences that he was subjected to. You have heard about the bouncing back and forth from the mother's unstable environment to the Department of Children's Services or Protective Services. From the age of not even 1 year old, all the way until Miss Richardson formally adopted him at the age of 12 or 13. But at that age, when he came to live with her, and he had been in many places, left in many places with a lot of different people, when he came to live with her at that age, the damage had already started. Now we have heard from what we call a mitigation specialist from Ms. Hall all this tumultuous background that he had to deal with. Now, like I said, there is no reason to excuse anything, or it is not a justification for the behavior. It is a factor that allows you to explain some of the events that took place in his life. You have heard about the repeated contact with the system. You have heard about the influences that he was in the neighborhood. You have heard about the lack of emotional support, the lack of nurturing. We as parents, or those that we are teaching our children the way they shall become. We are trying to. We nurture them, we guide them, we teach them. We are teachers as parents. None of that applied to Truman. Learning at a young age is based mostly on what our parents teach us. This is a fact. Guidance in life does matter, and it is one of the factors to consider. Finalized the adoption of Truman when he was 12 or 13, and he was the last one to reach her family. She had been trying to take care of every siblings and create a family-like environment for them. But he was the last one. He was the oldest of all the siblings. But he was the last one to be formally adopted. He was still bouncing back and forth between her at certain times in her life when she was able to take him to children's services, and the mother to whom he returned back and forth. Then at the age of 19, we have a 12-year sentence that is imposed, that did not redress any wrong that he might have done. He was 19 when he was charged and pled to that robbery. He was 19 when he went into federal custody. He did obtain a GED. But that he didn't know what to do with it. He was released, and he was experiencing trauma again, how to re-enter society. Couldn't find a job, or if he did, he could get enough hours to work. He had this sense of doom. We didn't know how to explain it at the time. He messed up, went back in, did all those things that he said he did. There's no denial. He didn't follow the rules. No denial. He's asking for help. Takes a while. You heard probation officer saying that services are available to those who need it. They can actually provide assessments. He lives with his sister. He feels like he's cooped up. He's taking too much space. He even tells his probation officer she might as well put him back in prison. Sense of doom, helplessness, depressions. Then, in May of 2015, he asked for help. And it's not until July the 10th of 2015 that he gets an appointment. And the fact that he's being diagnosed with severe depression, with psychotic features, and PTSD appears in the report of the probation officer in the file that they keep on July 30, 2015, which is 2 days before the incident of August 1st, 2015, the death of Sean Barton. Pastor White knew him from when he was an infant, with his sibling going to play basketball and being a place for those kids to go and gather in the neighborhood. He said that Tremaine and him lost touch because Tremaine grew up and moved away from the neighborhood. But it was still the voice of reason for Tremaine when he decided to turn himself in. He contacted Pastor White. And he did turn himself in to the marshal's office. He was the voice of reason for him, even though he had left the neighborhood. Now, the court in its instructions has given you 17 or 18 mitigating factors, and I urge you to go through them, because you will put the value that you each individually decide to put on, not what we, the defense, or the state, decide that it's worth it or not. It's up to you. It is your moral decision.
The judge ultimately delivered a sentence.
The jury, having found Mr. Wilborn guilty of first court, will set his punishment life imprisonment without the possibility of parole. He is rendered infamous. Mr. Wilborn continues to lose all of his rights and citizenship. This court will not set a fine on that verdict. The court, as the 13th juror, does again affirm the verdict that the jury convicted, if he continues to scream and shout obscenities, this court will make sure that Mr. Wilborn will in fact respect the administration of justice, and he will not decide when and if and how he comes to court. I want to thank the lawyers involved in this case, Mr. Henderson, Ms. Dwyer, Ms. Berg, Mr. Ganguly, Ms. Hall, Ms. Pasley, for your professionalism in court. I know it's been a tough case for all the lawyers, for the Bolton family. It has been August 1st, 2015, some 3 years and almost 3 months since this tragedy happened in your lives. I know that with the jury, no matter what verdict the jury reached in this case, no matter what sentence the jury sets in this case, would not repair the damage, would not repair the loss, would not repair the suffering that you all have gone through. It would not erase the events of that horrible evening on August 1st, 2015. But also Bolton lost his life doing what he has dedicated his life to, serving and protecting. Lost his life doing exactly what he should be doing. And I know this verdict, no matter what the verdict had been, no matter what the sentence would have been, would not erase, would not repair that damage that has been done. I hope it gives you some sort of closure, knowing that part of this case is over, that Mr. Wilborn has been held responsible for the death of Sean Bolton, and the jury has in fact made sure that Mr. Wilborn would never be released from prison.
Some individuals are unfit to be part of society. They remain indifferent to how their actions impact others. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.